Hello, all. Welcome to the Chicago Justice Podcast. I'm your host, Tracy Siska, also Executive Director of the Chicago Justice Project. Find out more about what we do at chicagojustice.org. Get involved at cjpnation.org. And if you want to donate and support, the Patreon link will be in the show notes. If you're listening to this the podcast for the first time, please hit subscribe. If you're on YouTube, subscribe and like. Smash that bell so you get alerts when we post. Really appreciate that. That all helps out our channel and the podcast. Real quick note, we have 2 more episodes of season 3 coming the next couple of weeks. After that, we're going to take about a week or 2 break, and we're going to start bringing you season 4, which is going to bring big changes to what is on what kind of content is in the podcast and what is exclusively to YouTube and our Patreon. I'll be bringing you more information about that in the coming weeks. Thank you so much for tuning in today. Really appreciate it. So today we're covering the Pretrial Fairness Act, or the PFTA. There's going to be some acronyms in the show today. Electronic monitoring, or EM, and the Cook County Sheriff's Office run by Sheriff Tom Dart. So what is electronic monitoring, or EM? How does it work? How do we use it? We talked today to Kareem Butler, a pretrial justice fellow at the Chicago Appleseed Center for Fair Courts, to answer just those questions. We also dig in a little bit to the problems with the Cook County Sheriff's Office and their response both to electronic monitoring and how that runs and how the courts run it, and also the Pretrial Fairness Act, or the PFTA, and their response. It seems like resistance or rebellion against the act. And what you're going to get into with Dart, and this has been in the media a little bit, but not anywhere near enough, is that he was on some kind of panel, and he said too many dangerous people are on EM. Now, because since 2014, with the Chicago Police Department's hyper concentration on arresting gun possessors or pursuing gun possessors, rather than going after the people that actually commit violent offenses with the gun. It is a felony to possess a gun in Illinois without a FOID card, but it is not a violent crime. We've talked about that, or we'll be talking about that on our Patreon channel very soon. Dart and Rahm Emanuel in previous administrations, and Lori Lightfoot's last 4 years, and her superintendent David Brown for that same period of time, all tried to change the definition of violent crime to include just possessing a gun illegally. And that's all it is. The crime is called unlawful use of a weapon. And everyone thinks, oh my God, for that title, you must actually have to use the weapon. No. It just means you possess the gun without having a fire owner's identification card. That's all it is. Well, the over-reliance on the police department on arresting people possessing guns and their pursuit of that has meant there's all kinds of increased people for those crimes out on bail or rotting in Cook County Jail. What the Pretrial Fairness Act did is basically forced in this bail reform, which basically means we're not going to let someone sit in jail waiting for trial just because they're poor, when at the same time someone who's got the money can post money and get out. No. If you're going to be in jail, you're going to wait the trial, then you're all going to be in jail. And if some can get out, then everyone's going to get out, right? That's what the Pretrial Fairness Action did. Dart, Lori Lightfoot, David Brown, her superintendent, don't like that. And they kept blaming and pointing to the courts. And so Dart said on this panel, hey, too many dangerous people on electronic monitoring. Well, can you point to a huge or large or even noticeable uptick in violent crime since this has been going on? And the bail reform started in September of 2017. As I remind you, crime went down in 17, 18, and 19 in Chicago, and then started going up in early 20, as it did with many cities around the country, mainly because of the pandemic. And when pressed about, hey, point us to those violent crime uptick, he couldn't and had to admit it didn't exist. So it's just a moral objection he has. Damn the science, damn the evidence. And if you look at Mayor Lightfoot, same thing. David Brown, same thing. David Brown's known to be a liar. He was proven to that in the police accountability system in Dallas. He served a suspension for lying. Damn the facts, damn the science. So what we're talking about today is, how does the sheriff's office administer EM? What is EM? How did the sheriff office and court administer electronic monitoring? Who's on electronic? Who was on electronic monitoring before? Who's on it now because of the PFTA? And how does that all run? And what is the damage to people that are on electronic monitoring? And I'll tell you right now, there's endless science now to prove that when you stick people out on probation or parole or even pretrial release, and you give them a heightened level of scrutiny or oversight or restrictions or reporting obligations that is not fit or calibrated correctly to the amount of supervision they really should need, they end up failing at much higher rates than if the calibration was correct. It just does. And there's science to prove that. But Dart, Lightfoot, David Brown, damn the science. It's funny, Lightfoot was all about the science when COVID, for the most part, but not about the science in her justice reforms. That's for sure. And it showed when they fired her, and David Brown fired the head of the Office of Constitutional Policing. This is just who they are. Okay. So to do all this, we talked to Kareem Butler, and I hope you enjoy the interview. I will be back with you after it. Kareem Butler, thank you so much for joining on the podcast. We really appreciate it.
Sure. Happy to be here.
All right. So today we're talking about electronic monitoring. Can you explain to my audience what is electronic monitoring for those who don't know?
Sure. So electronic monitoring encompasses a couple of different, forms, but essentially it's a technology that's used by the courts to exert supervision over individuals either on a pretrial status or in a probationary status. And like I said, it encompasses different forms of technology. There could be radio frequency electronic monitoring devices or GPS powered electronic monitoring devices.
Okay, so in Cook County, this is administered by the courts, or I should say administered by the courts. People are assigned to electronic monitoring, mostly pretrial people, from the courts.
Mm-hmm.
The program's administered by the Cook County Sheriff's Office, which is run by notorious or infamous or politically, he's always never shy to get in front of a camera, Tom Dart.
Right.
Okay. Who typically, before the Pretrial Fairness Act, who typically qualified for EM? I'm going to call it EM, ladies and gentlemen, just so you know, because I know the numbers have shifted greatly about the people that are on electronic monitoring now. Do we know what was the typical person that would have been on electronic monitoring pre the passage of this law?
Well, typically, for one, I would just emphasize that this program primarily affects lower income individuals, and particularly people of color, especially Black people throughout Cook County. And so it primarily targets, not only racial minorities throughout the county, but of course, as I mentioned, lower income individuals. And when you look at, how the numbers have really fluctuated over time, Cook County has for decades really boasted a massive electronic monitoring population. It's the largest population of individuals placed on electronic monitoring of any major urban jurisdiction. And since, the passage of the Pretrial Fairness Act and the reforms that have come with that, and since COVID-19, we have seen some declines in the number of individuals on electronic monitoring. But what I would emphasize is the numbers that the population itself is still really significant. It's on an average day, the population of individuals on the sheriff's electronic monitoring program is over 2,000, and for the adult probation electronic monitoring program, which is not for individuals in a pretrial status, which is difficult to also ascertain because of issues with transparency. The numbers are around 1,000, above 1,000. And what I would say is, as far as what types of individuals and the types of charges that they're facing, or the offense categories of individuals who are placed on electronic monitoring in Cook County. We've seen some fluctuations, and in the report that we actually co-authored and helped release in September of 2022, we outlined a couple of different categories and how they fluctuated over time. So we've seen individuals who were facing drug charges in a pretrial status. We've seen those individuals decrease, those individuals facing those specific charges decline over time. For individuals facing charges, for example, like gun possession charges, we have seen those numbers go up. But the overall number of individuals on electronic monitoring, particularly since COVID-19, has dropped. But because of the nature of Cook County's electronic monitoring, the fact that it has two separately run programs, one under the Office of the Chief Judge, one under the Sheriff, it can be, we have a better understanding of how many people are on electronic monitoring under the Sheriff. Easier to obtain that information because of issues relating to public disclosure laws in Illinois and an inability to really submit requests for Freedom of Information Act requests to our courts. There's a lot that we don't know on a day-to-day basis about who's on electronic monitoring under that program, under the Office of the Chief Judge. But as far as the total is concerned, decreased a little bit. But I would say that COVID-19 was a greater determinant of a greater marker of when we started to see the number of individuals go up during the pandemic. Since then, the numbers have crept down a little bit.
And do you have a theory as to why the numbers are creeping down? Is there just because the judges are more willing to hold people pre-trial now than they were during COVID's worst of times?
You know, it's a difficult question to answer. I wouldn't, I'd be speculating a little bit as to say exactly why. I would just emphasize too that these declines haven't been particularly dramatic. Again, I would just emphasize, the number of people on electronic monitoring in Cook County is still massive, and it far outpaces other major jurisdictions. For example, New York and LA, which have massive systems, case management systems, have numbers in the hundreds of individuals placed on electronic monitoring on a pretrial basis. Whereas, Cook County, we're far and away from that. So even though there has been some decline, I wouldn't feel comfortable speculating exactly as to why that has come to play.
So I think I took that the wrong way, and I should have taken what you said. So Cook County is this huge EM population compared to LA and New York. Mm-hmm. Especially if LA and New York are in the hundreds. New York is 3 times the size of Chicago, plus, ladies and gentlemen, plus 800,000 or 900,000 extra people. Is it because New York and LA have a smaller list of things that people are out that require them to be on EM while they're waiting pretrial and they're out? Or is it because New York and LA are holding more people in their jails? Do we know that difference?
I would say it has more to do with, Cook County has a legacy of reliance on electronic monitoring that differs from most other jurisdictions. Most other jurisdictions, they have electronic monitoring as an option in their toolkit of community supervision, right? So there's a spectrum of community supervision tools that the courts or whoever's monitoring an electronic monitoring program can impose on individuals on a pretrial basis. So, there's intensive community supervision that would involve, meeting with a pretrial services officer periodically, and that, for example, wouldn't necessarily involve electronic monitoring. Electronic monitoring is one form of community supervision. And it's in Cook County, there's been a legacy of reliance on it as sort of the primary means through which people can be observed or monitored while in their community pre-trial. And that has really, to me, played the largest role in why, compared to a lot of other jurisdictions, we see such, an outsized use of electronic monitoring here as opposed to elsewhere.
Yeah, and I'm sure. Well, let me ask you: do we know the economics of this? Is it cheaper to put someone on EM than it is to have them on intense supervision in the community?
No, it's actually more than double the cost of, regular intensive supervision. I would also emphasize there's no significant or meaningful evidence that electronic monitoring has a statistically significant impact on the likelihood that someone will reoffend. There's no evidence that it has any benefit on or impact on failure to appear rates.
Mhm.
Um, so, you know, it's both. There's no evidence suggesting that, electronic monitoring provides some sort of public safety benefit that other forms of community supervision um, don't. And there's no evidence that it is having a positive impact on people's appearance rates in court, right? I mean, the evidence that has come out from, the report that we put out in September, highlighted the fact that for the majority of individuals on both electronic monitoring programs, the vast majority are reappearing in court at their scheduled court dates, and a very, very small percentage of individuals are reoffending, either while on EM or after their stint on electronic monitoring.
And it costs more.
And it costs more. It's inefficient. Wow. It's also difficult to commute. The fact that these two programs are housed separately, on top of the fact that it's costly, means that it's also difficult to the separation in the management of these programs makes it difficult for communication to happen between the administrators or staff who are overseeing the program or overseeing an individual's stint on the program and the court. So that communication creates problems. People on electronic monitoring, if they need have a request approved for them to be able to go to their child's play or to be able to attend a specific appointment, right? Historically, that has been something that requires a lot of time in order for that approval to be provided to that individual. And having these two programs managed separately creates greater lag and delays in things like that moving along.
Oh, yeah, it's kind of ridiculous. You would think that they'd have some kind of electronic system where you could file that request, and it would take a very short order, a period of time for that to happen. Mm-hmm. I can pay my taxes electronically. The federal government gets my money. They should be able to request it. Go see your, for instance, go to the grocery store or something like that.
Right.
Okay. So before we get in the dark, what did the Pretrial Fairness Act, what was its impact on electronic monitoring?
Sure, yeah. So the Pretrial Fairness Act did a few things. For one, the Pretrial Fairness Act, before the Pretrial Fairness Act was put into place, people could be routinely denied what's referred to as essential movement by a judge, right? So they'd be in bond court, which is their first appearance before a judge, if the judge decided to place them on electronic monitoring per their conditions of release. In a lot of cases, judges would say, okay, EM with no movement, meaning that person, has to, if they're placed on house arrest, that person, if they want to be able to go do something, they have to get advanced approval from the court, right? What the Pretrial Fairness Act did is require that individuals have essentially 2 windows per week that are essentially 2 12-hour windows per week where they can accomplish various essential tasks, right? Where they can go to the store, where they can handle appointments, where they can handle other, necessary needs or daily tasks. And it's designed to be able to provide them with that opportunity without fear of reprisal. And that's one really important thing that the Pretrial Fairness Act did, because a lot of people historically would be reincarcerated if they tried to go handle a necessary, task. If they were trying to go to the store, if they had to go to an appointment, or if it was an emergency, right? If they needed to leave, it really created a situation where they were putting themselves, unfortunately, or the nature of the program was putting them at risk of reincarceration. Sheriffs, deputies show up, they bring that person back into custody, and now that person could potentially be in jail all the way up until their trial date. The next thing the law also has done is create a system where every 60 days, for most individuals, they'll have an opportunity to have their conditions, specifically their electronic monitoring conditions, reevaluated by a judge. This gives them a chance to figure out whether that person can be placed on a less restrictive, less harmful form of pretrial release, while still ensuring public safety and future appearance in court. And then also, everybody placed on electronic monitoring, specifically home confinement electronic monitoring, under the Pretrial Fairness Act, is required to be given credit toward any potential sentence they receive upon conviction. So if someone spends 2 years on electronic monitoring, if they are convicted at trial for whatever charges they're facing, those 2 years they spent on electronic monitoring are to be credited toward their sentence. So those are, in a nutshell, the biggest reforms that the Pretrial Fairness Act made to electronic monitoring.
So are you saying, I think you just said they weren't given credit for their time on electronic monitoring? So if they spent 2 years before the PFTA passed, if they spent 2 years on home confinement, they weren't given that? So if they got a sentence of 3 years, they weren't credited with the 2 years before that?
Yes, it wasn't plenty of people could serve time on electronic monitoring. It could be, 2, 3 years, it could be some months, however long it may have been, and that wouldn't necessarily be credited toward any sentence they may have received. This now makes it, a requirement under law that they have to be given credit toward any potential sentence, right? Which is important, because, we want to, it's important that people understand too, electronic monitoring isn't some very, isn't some minimally invasive, harmless form of supervision. It's essentially an alternative form of incarceration, and a lot of people refer to it as e-carceration for a reason, right? People have trouble, people historically, because of the strict rules, especially in Cook County under electronic monitoring, things as simple as just going outside to take the trash out, going to, to do laundry, watching your kid play out front could put you at jeopardy of being rearrested. So the nature of the program has been really draconian, and the law has in a few ways tried to make it less restrictive and less harmful, and to ensure that people have a chance at avoiding future time in a traditional carceral setting by crediting them for whatever time they spent on electronic monitoring home confinement.
Okay, what is the can you give us some insight into the history of the Cook County Sheriff's administration of the program? Is their reputation as being good? Is it being not great? Where are we? I mean, it's the Cook County criminal justice system, so I have my preconceived ideas of what that was going to be like.
Right. Yeah. So not good. In the short version is, the Cook County Sheriff's EM program has been is regarded as being really strict, not only across the country but within Illinois. Right. There are other jurisdictions that, their electronic monitoring is used statewide, right? It's operated by the Illinois Department of Corrections. But the Cook County electronic monitoring program is unique in the sense that its restrictions are, the restrictions that are imposed on individuals pretrial typically are steeper than the restrictions placed on individuals pretrial or on individuals pretrial elsewhere in Illinois. And the sheriff's office, even when it comes to the Pretrial Fairness Act and the reforms that I mentioned, the sheriff's office has in a lot of ways, narrowly interpreted features of the law, these reforms, to make sure that, to basically create a situation where as few people as possible are benefiting from these reforms. For example, when it comes to this essential movement window, right? This has really been created as, and should be observed as, a floor, right? Not a ceiling on what's possible when it comes to essential movement and freedom of movement. The sheriff's office has really conceived of this as, a ceiling as opposed to a floor. So no more than those 12 hours will be afforded to individuals on a pretrial basis a lot of times if they're on sheriff's EM in Cook County. 12 hours, excuse me, 2 12-hour windows. And the reality is, that reform is important, but there are a number of situations where someone may need to leave wherever their home is, or wherever they are serving out their electronic monitoring stint. It could be a situation where someone needs to flee because of safety reasons, because wherever they are is no longer a safe place, whether it's whether it's caused by domestic violence, whether there's some other emergency that they need to flee the home for. And the sheriff's office has really created situations where rather than providing people with an opportunity to have freedom of movement on a reasonable basis, they are narrowly interpreting that feature of the law to make sure that outside of those 2 12-hour windows that people can have throughout the week, they are still highly and heavily monitored and restricted from leaving wherever their home address is. And then I would also add, too, this feature of the law that requires individuals to have, a status hearing essentially every 60 days. That's in order to make sure that they can potentially be placed on less restrictive conditions for pretrial release. There have been cases where individuals haven't been provided with that opportunity to have their status hearing at the 60-day mark when they've been placed on electronic monitoring. Instead, they're languishing, on electronic monitoring for 100, 120 days, however many, well beyond what is now required by law. So there are a few ways in which, the sheriff and the county have been creating situations where, it's the reforms that have been put in place aren't fully reaching their potential. And historically, this office has created situations where even for something as simple as just going to take out the trash, people can be reincarcerated. False alerts are also, I just would add, a major problem for electronic monitoring technology. And in Cook County, a lot of people deal with false alerts when they're on a pretrial basis. The GPS technology that people are placed on isn't infallible, right? None of the technology that people are placed on electronic monitoring is infallible, but the sheriff specifically relies heavily on GPS technology. Everyone on electronic monitoring under the sheriff's program is on a GPS tracker. And you can have drift where it seems like this person is away from wherever wherever they are permitted to be, right? When in reality, they haven't violated any of the terms of their pretrial release. And because of that false alert, you have individuals who are, being met by sheriff's deputies, who are being arrested, in front of their families, who are, having unnecessary contact with law enforcement because there's this automatic assumption that they must have intentionally or willfully violated the terms of their release. And so the county, specifically the sheriff's electronic monitoring program, does not have a positive reputation among community members, especially the communities that are most often targeted by electronic monitoring.
All right, this is one of the last questions. Why do you think, one of them, could you hazard a guess, and you may not want to guess, but what the motivations are for the sheriff's office to be this way? If all the numbers you detailed to us early on are true, and I'm 100% believing that they are. What is going on with the sheriff's office?
I think the sheriff's part of the sheriff's, commitment to the electronic monitoring program, I think, is the same. It aligns with the same overall belief in this tough on crime, punitive approach to dealing with public safety issues in our communities. So I think part of the sheriff's commitment to this issue is political in nature. I think when you look at this issue, and especially the way public safety is discussed in Chicago, right? We have, a lot of people who focus really heavily on this issue of gun possession and gun violence, right? So I mentioned earlier, the number of people who are facing gun possession charges on electronic monitoring has been going up steadily. While drug charges have been coming down, gun possession charges, or the number of people facing those charges on EM has been going up in Cook County. I think, that is the reason why I bring that up as an example is because in most situations, people who are arrested for gun possession charges, there was no violence that occurred, right? A lot of people who are being arrested for gun possession charges are either facing class 4, class 3 felonies in which no violence occurred. And in many cases, there was no prior felony offense or no prior gun possession offense, or it's for a class 2 felony in which, for example, they may be a felon, they may have a felony record for a prior gun possession charge. In either case, many of these individuals, the vast majority of people placed on electronic monitoring from gun possession are there without having committed any act of violence with that firearm, right? With the alleged firearm that led to them being put on EM. And I bring that up because if we're so concerned about public safety, if that's our main concern, then why are we placing so many people on electronic monitoring who are low risk when it comes to public safety, who are not facing charges for which they have harmed another person or put someone else's safety in jeopardy? I think it's important to point out that if we're concerned about public safety, we should see that borne out in who or how resources are being applied in terms of electronic monitoring and in terms of who's languishing on these devices. And so I would say, the sheriff is in many ways responding to a lot of public backlash and responding to the narrative surrounding public safety in Chicago and in Cook County. There's a belief that, in order to address public safety concerns, we have to be really punitive. We have to have as wide of a net of surveillance and of incarceration as possible. And the data just doesn't support that. That's an effective approach.
Yeah, it's I, for one, am happy that it seems like politically he's stuck. I'm all for Dart retiring. I think that would be a wonderful, wonderful thing. But he is politically stuck. I think he may run for Kim Foxx's office. I think he will lose that office. But I don't think he has another office that he can go on. I do think this is all political. He was on he was at some event where he's on a panel and he was talking about electronic monitoring and going off about how many people are there for gun offenses. And people said, well, how many of those are the vast majority of those, or if not all of those, have they committed violence? No. Have a large percentage of them reoffended? No. But I still don't like it. And it's like, oh, it was like listening to a white male version of Lori Lightfoot, right? It was the same rhetoric that wasn't based on anything other than their very Trumpian views that they know better than everyone else and they know better than science. People criticize Trump for spouting out about stuff, but we have our own people in our city that spout out about stuff that is totally in denial of all the data. And the idea that any people like us who support these programs that can back it up with data and science are somehow anti-public safety. And I know, I can tell you from the research science criminologically, we know if you put too many restrictions on people in their probationary period or on parole, or on pretrial, the more you heap on restrictions, the more likely they are to fail. And
Exactly.
when you put people who don't deserve the restrictions on more restrictive things than they should have been on, their likelihood of failing is skyrockets. I know there was big studies done in Kansas and in other places where it's just like, no, you need to understand who you're putting there and why you're putting them there. They have to understand why you're putting them there. If they think it's ridiculous and it doesn't need it, you're in trouble. And that's trouble for all of us. We need systems where they get through these things without reoffending at the highest possible rate and in the best possible conditions, so they're less likely to reoffend down the line. But that doesn't make it into the Chicago media most of the time. It does not make it into the political discourse most of the time. And we are very short-term thinking people. And when you get politically aggressive people, they do things like this for the headlines or to make sure they stay out of the headlines. As if for some reason it would be DART's fault if someone on electronic monitoring reoffended. I don't understand.
And you know, there are calls right now. There have been, you know, attempts right now to end the essential movement provisions within the Pretrial Fairness Act to, you know, go through the legislature and pass a bill undermining those protections within the Pretrial Fairness Act. And, you know, on the basis of this on the basis of a few small incidents in which, you know, a very slim percentage of the overall number of people on Sheriff's EM were rearrested, right? Some for violent offenses, right? And to that, one thing I would say is, you know, are we, if we're trying to achieve, if we believe that ending mass incarceration is solely dependent on having a 100% success rate with all of our reforms, we'll never end it. We'll never get away from it. And I think, you know, the other thing that, you know, these attempts to undermine essential movement, which again is a floor, is it's not a ceiling for progress. The other thing that they miss is, you know, they assume that, okay, instead of essential movement, we can just rely on a judge to mandate that someone is allowed to go from work to home, work to school. We can allow for a judge to design the parameters for someone's electronic monitoring regime. The problem with that is we've been there. We've done that, right? We've seen plenty of individuals who were denied movement outright by judges in Cook County, right? Meaning anywhere they wanted to go, if they were, you know, confined to their house, anywhere else they wanted to go required advanced approval. If that event, if you have an emergency, or, you know, if you're if you're going to be, if your spouse or your partner is going into labor and you need to be at the hospital, you need that approval immediately. You can't wait a week, 2 weeks. If you need treatment for an urgent medical crisis, you can't wait necessarily a week, 2 weeks in order to get to the doctor. You need that approval now. And in what's happened in a lot of those cases where you're solely relying on a judge to provide the parameters within which people can engage, you know, be on their EM regime, what happens is they run into barriers in terms of getting to necessary appointments, being able to live their lives functionally, right? And so it's, you know, this idea that we should go back to that. We've been there, we've done that, it doesn't work. Even when judges are creating these parameters that are meant to, you know, guide how people exist on electronic monitoring, it's in many cases they're not accounting for everything. They're not accounting for every need or every emergency that might arise and require someone to have the opportunity to leave their home or wherever they're placed on home confinement.
Yeah, I mean, this always brings me back to a phrase early on in Law and Order, the show, back when it first started, because I'm that old. And the head prosecutor was telling the other prosecutor, in politics, there's two options: do something, do nothing.
Hmm.
Do nothing has less risk, right? So yes, Dart and
Yeah.
everyone and the mayor and everyone wants the judges to make the decisions about the monitoring and the movement and stuff, because then the if it goes wrong, it's on them,
Yeah.
right? Because
Right.
we're a city that if one case goes wrong out of a 10,000, that's it. We got to change the rules to make sure that one thing never happens, as if that's going to do it.
Right. Right. Exactly. So lots of inefficiencies with the program, and we aside from advocating for them to consolidate the program under one office to avoid all of these nightmares in communication and other costly problems. That Cook County needs to massively reduce the number of people it places on electronic monitoring, period. Um, and it would be to not only a public safety benefit, but it would also, just alleviate a lot of the harms it causes people who are ordered to electronic monitoring and their families.
Yeah, it's hard to have an atmosphere where you can do that when you have a mayor and a police superintendent who both just left, who constantly were pointing the bad, lenient judges as
Mm-hmm.
for the crime problems in Chicago. And it cost for people in administration. They just kept quitting because she was lying, but it didn't deter her. It's hard to have um, conversations about what the data says and how things should be, to make people more successful in this program when that atmosphere has been so poisoned.
Right. Yeah, it's toxic, and we need to, continue. That's what we're trying to do, is push the narrative away from a lot of that toxicity into, actually relying on evidence.
Yeah, hopefully we'll see that day in Chicago. All right. Kareem Butler from the Chicago Council of Lawyers and the Appleseed Fund, thanks so much for joining us. We really appreciate it.
Thank you.
Thanks again to Kareem Butler for sitting down with us. We really appreciate it. It was a great interview. Hope you really enjoyed that. The Lying by Dart, by Lightfoot, by David Brown, the poisoning of the well, the alt-right in Chicago, is not helping solve the problems that Chicago has. Chicago does have problems, but nobody wants to address the main issue. And I'll keep harping on this podcast. I'll be harping on the next season also. It's poverty. No one wants to really address that. They throw token amounts of money at it, and they blame the courts. Lightfoot was blamed the courts, the sheriff, Tony Preckwinkle, Cook County Board President, Kim Fox, the Cook County State's Attorney, everyone but her. She was in the House of Power. She could have done something more to address the root causes. She loves talking about them in the rhetoric, just not governing to them, to address them. Instead, we scapegoat and exploit for political benefit, which is what the alt-right in Chicago does. Lopez, Spizzato, Napolitano, Beal, and Riley. You can go down the list of people that, if they were in any other city besides Chicago that is controlled by the Democrats, they'd be considered Republicans. And like Lopez, Spizzato, Napolitano, alt-right, no doubt about it. This exploitation is a tradition in Chicago. It just is. It just is. And it's sad. The PFTA is backed by science. It's backed by science and facts. So is bail reform. But don't tell that to Dart, Lightfoot, David Brown. That's science they don't care about. That's science that doesn't agree with their political agenda, their alt-right views in this aspect. It just doesn't. Okay, ladies and gentlemen, thanks again for tuning in. I really appreciate it. Once again, in a couple weeks, we have a couple more weeks of season 3. We have interviews set up with Carlos Ballesteros and Kelly Garcia at Block Club. I believe we're going to be double teamed there. And then also another episode with the Chicago Inspector General, Deborah Witzberg, to talk about a report that the office has put out related to Rule 14 violations. That means officers who were accused of lying during an internal investigation, and then was sustained, and then they were found guilty by the police board if they had long suspensions, but not fired. And there was a recent article that came out based on that report, said there's hundreds of officers, or at least 100. I'm not sure hundreds is right, but at least 100 officers that have Rule 14 sustained misconduct allegations against them, and they still kept their job. How? No one knows. It's been a bane of our existence at CJP, the bane of why we have the police board website so people can see what's going on. If you want to get to that, cpbinfocenter.org. Okay, so we have those 2 sets of interviews coming, and then season 4 will probably take a week or 2 off, and then seasons 4, big changes are coming. Also, changes are coming to our YouTube channel with a bunch of unique and independent content, stuff that'll be independent from the podcast. And then we're also going to have content flowing to our Patreon at least once a week. Okay, thank you, everyone. I appreciate it. I'll be back with you hopefully next week.